obligations to perform and rely on legal defenses without satisfying the requirements as agreed upon in the contract. Because of the respondent's persistent conduct in riding roughshod over my client's rights, we are here at arbitration today. With this,
may I just ask you a short question? Have you attempted to amicably settle this dispute in good faith before resorting to the arbitration in line with section Article 12.2 of the contract?
Yes, Madam Arbitrator, but before we address that question, the ancillary question that must be asked and assessed is that that 12.2, or rather the precondition to negotiate, must be in fact enforceable, and that is actually our submission today. So with this, I shall address this tribunal on 3 issues. That firstly, that there are no jurisdictional bars to prevent the present dispute, and this is labeled as issue number 5 on page 5 of the record. And secondly, I'll establish that the respondent has breached the contract, and this submission would address issue number 1. And lastly, my client's entitlement to damages and the enforcement of the contract, and this will deal with issue number 4. My co-counsel will speak on why the respondent cannot rely on force majeure and frustration, which are issues 2 and 3 respectively. I now turn to my first submission on jurisdiction, which is issue number 5 for clarity. Now we submit that this tribunal has the jurisdiction to hear the dispute as the precondition to arbitrate is objectively incapable of enforcement. As what Madam Arbitrator has pointed out, this relates to clause 12.2 of the contract. Now, if the tribunal can turn with me to page 6 of the record, this is entitled Annexual 1, which identifies the relevant clauses of the contract. The precondition mentioned can be seen in the 2nd and 3rd line of clause 12.2, which provides, as I quote, that parties shall attempt in good faith to resolve all disputes amicably between themselves. While this may seem rather unintuitive since parties have taken pains to include the precondition to negotiate, we submit that such a vague and nebulous provision, one that is bereft of any expressly provided objective standards, is incapable of enforcement. So it is trite law for obligations to be enforceable. The object and the means of carrying out the obligation must be sufficiently certain. So in the context of this or multi-tiered dispute resolution clauses, English courts have only strictly enforced such clauses where clear and objective guidelines are expressly provided in the clause. Can
I ask you a question?
Yes, Mr. De Silva.
Is it your position that the clause 12.1, the requirement for discussions is an unenforceable clause or position, and therefore it cannot be relied on as a precondition? Is that your position?
Exactly, Mr. Arbitrator. That is our position, and this is because courts have only enforced such clauses where objective guidelines are expressly provided. And this is especially important because in a multi-tiered dispute resolution clause, parties, the courts, and this tribunal would need to know objectively the minimum standard of participation and when or how the process is to be properly exhausted without breach. So perhaps to help this tribunal understand the level of certainty that's required, allow me to use 2 cases to illustrate. In the 2002 English High Court case of Cable Wireless and IBM UK, it concerned the enforceability of a pre-arbitration obligation to undergo a dispute resolution process. The clause required parties to, as I quote, attempt in good faith to resolve the dispute or claim through an alternative dispute resolution procedure as recommended to the parties by the Centre for Dispute Resolution. The court held at page 1049 that such a clause is indeed enforceable, as parties sought to identify and enforce a dispute resolution mechanism that contains detailed provisions such as the duties of the participants, the apportionment of fees, expenses, and the model procedures. Now, contrast this to the 1991 Commercial Court case of Paul Smith. And in that case, the clause provided that parties shall strive to settle the disputes amicably. But if they are unable to do so, the difference or dispute shall be adjudicated under the ICC rules of arbitration. And in that case, the court held at page 131 under the first column that the obligation merely amounted to an agreement to agree, which was too uncertain to be enforced. So in the present case, clause 12.2 merely provides that negotiations must be conducted in good faith. It does not provide how long such negotiations should last, who the parties are, what their obligations entailed, and how the process should be properly discontinued.
So what you're saying is the whole uncertainty of the details does not makes it not obligatory on you to comply with it, right?
Yes, Madam Arbitrator, that is our submission. And we note that the respondents have relied extensively on the case of Emirates Trading and Prime Mineral Exports. However, they failed to highlight to this tribunal that the facts of Emirates are wholly distinguishable. In Emirates, the clause required parties to first seek to resolve the dispute or claim by friendly discussions. And this is the most important point. If no solutions can be arrived in between the parties for a continuous period of 4 weeks, then the non-defaulting party can invoke the arbitration clause. So the uniqueness of Emirates was due to the fact that it was a time-limited obligation to negotiate. And the court expressly qualified at paragraph 63, and I quote, that there was no appellate authority which binds this court to hold that a time-limited obligation to negotiate is unenforceable. This is consistent with what we have submitted earlier with the strict requirements for dispute resolution clauses to provide objective benchmarks to allow a deciding body, and especially this tribunal, to determine compliance and breach. Therefore, we submit that the clause is unenforceable as it provides no objective standards for this tribunal to ensure enforcement. And because of its unenforceability, non-compliance would not amount to a jurisdictional bar. Now,
So in other words, is it your position that you have not complied with this clause, but because it is unenforceable, you are not prevented from proceeding with arbitration? Is that it?
Yes, Mr. Arbitrator, that is the crux of our submission. Now, since we have established that there are no jurisdictional bars to prevent this present dispute, I will move on to my second submission regarding the breach of contract. For clarity, this is issue number 1, following page 5 of the record. Now, the respondents in their submissions failed to address their minds to the significance of the refund. So the question of breach must be answered as to whether the contract entered into February was breached and whether the refund, as requested by my client, affected the existence of any breach. So, and with this, I would like to direct the tribunal's attention to page 3 and 4 of the record. This is a statement of relevant facts, and I would like the tribunal to pay particular attention to the events from the 12th of July to the 26th of October. Members of the tribunal, the respondents had promised to deliver the chemical fertilizer by the 13th of July, as stated in the second page of the clarificatory document. However, till now, the chemical fertilizer is undelivered. This will therefore amount to the first breach. As a result, my client then requested a return of the contract sum so as to purchase other chemical fertilizer to prevent more damage. And this was part of my client's attempts at mitigation. My client then cancelled the refund and proceeded to enforce the contract at the agreed price and quantity on the 4th of October, which the respondent accepted. Following the conclusion of the cancellation, the respondent repudiated the contract by indicating its refusal to perform. This would therefore amount to the second breach. Now, we submit that a refund did not indicate an intention to discharge, but was merely part of my client's attempts at reasonable mitigation. Now, if the tribunal could turn with me to page 10 of the record.
To get into that question, could you assist me with, by telling me at what point did the title of the goods on board the MV Lorient pass on to the buyer claimant?
Madam Arbitrator, there was no passing of the title of the goods because at 12th July, the goods arrived at the port and it was subsequently detained by Rivendell Customs. Until now, the chemical fertilizer has remained undelivered to us. And
What
therefore,
is the date of delivery that was, is there a date of delivery?
yes, Madam Arbitrator, if you could turn with me to page 2 of the clarificatory documents. The document is entitled Answers to Clarifications.
Yes.
And sorry, my apologies, page 3 of the clarificatory documents. At the top of the page, under the header Annexure 2, the question was asked, what was the date of arrival for the original batch of fertilizer? And the answer
That is page 2, eh? That's page 2, not 2, 3. Yeah. Yeah. What is the date of the original batch?
Yes, Madam Arbitrator. And the
Yeah.
date shows between the 15th of March 2021 to the 13th of July 2021.
Mhm.
And because, yes,
In terms of the Sale of Goods Ordinance, such article, Sale of Goods Act 9 of 1979, 20A, does that have a relevance? That when a party buys part of a common bulk, that he becomes the owner in common, and that when the money was transacted and paid in, that was the time at which the title passed as soon as the goods arrived?
well, Madam Arbitrator, while we note that the Sale of Goods Act does provide that provision, we note that on the facts, especially if the tribunal could turn with me to page 8 of the record, this is Annexure 2. The respondents had apologized to my client to say that had apologized based on the first line, which they said, we would like to apologize for the late arrival of your order.
Mhm.
And this was sent for your late order. But for late order, but Madam, I apologize, Madam Arbitrator. The right email that I was referring to is actually
Annexure 2?
no, my apologies. Annexure Annexure 3, sorry, my apologies, which is page number 9 of the record.
Mhm.
The respondents had apologized to my based on the fourth line of the email, and they had apologized for the late delivery of the chemical fertilizer. This is after the fact that the chemical fertilizer had arrived at the port on the 12th. This means that title wouldn't have passed until the chemical fertilizer was passed to the location of the claimants. And therefore, this amounted to the first breach.
So in other words, your position is that the goods were never delivered.
Exactly, Mr. Arbitrator. So once again, returning to page 10 of the Moot problem, which is the email regarding the refund. On the facts, my client never attempted to expressly terminate the contract. In the present case, my client needed to mitigate against the losses caused by the non-delivery. This can be seen in the first and second line of the third paragraph of the email, where my client stated that the delay affected the overall quality and well-being of the plants. Thus, the refund must be seen as an attempt to obtain a return of the purchase price so that my client can continue to purchase other chemical fertilizers so as to minimize potential losses. If my client wanted to discharge the contract, it wouldn't have taken pains to explain the damage caused to its plantations and to justify why to seek alternative performance. Therefore, an argument on an agreement to rescind or to terminate the contract would fail because there was no meeting of the minds between the parties to do so.
Can I pause you there for a moment?
Yes, Mr. Arbitrator.
That letter, Annexure 4, which you were referring to. Right?
Yes, Mr. Arbitrator.
It basically says that now by the time there was a delay in delivery, which according to you was a breach. So therefore, you are saying basically due to this, we have been compelled to place orders for chemical fertilizers from other suppliers. Right? And then you request for a refund of the money.
Yes, Mr. Arbitrator.
So does not that amount to a termination of the contract by you?
Mr. Arbitrator, for there to be a termination, our submission is that the refund in and of itself cannot amount to an agreement to terminate the contract, because to simply focus on the last line, which says compelled to place orders, will not be reading the email in its entirety. The context must be given a court, which is that the context is that my client had suffered losses arising from the non-delivery, arising from the delayed delivery. And because of this, the refund is merely part of my client's attempts at mitigation. And therefore, is not an unequivocal representation to terminate the contract. If it were to terminate the contract, my client would have expressed it in clear and unequivocal words. That is the crux of my submissions, Mr. Arbitrator.
In that context, if you look at Annexure 5, which is basically the acceptance of that letter by the other party, would you still argue that there is no termination? And the second question is, are you not really asking for a return of the consideration that you've given in Annexure 4?
Well, Mr. Arbitrator, we note that there was an acceptance of the refund by the respondents. However, on the 4th of October, the refund was ultimately cancelled. And the refund was cancelled because my client sought to enforce the contract at the price and quantity. And therefore, the refund, the issue of a refund, seen in light of the entire in the chronology of the actions of the parties, show that there isn't a discharge of the contract. And because of this, there is an enforceable contract in the present case.
Can I ask, I think the question is, there is an agreement on the refund, and then when the agreement on the refund takes place, as Mr. De Silva said, the consideration goes out of the main contract, right? So when there is no consideration, can you still have an enforceable contract for something that took place after the original consideration had taken place? If you get what I mean, consideration was there, but with the refund, consideration went out of the picture. So
Yes,
then does it not become unenforceable?
Yes, Mr. Arbitrator, that's exactly the next submission that we're going to make. Because the refund was ultimately cancelled, there was no fresh consideration. And even if an agreement to discharge was indeed made, the lack of consideration would make that discharge a mere gratuitous promise, and which is unenforceable at law. Therefore, there would still be an enforceable contract between the parties, which the respondent would have breached by repudiating on its obligations. And
right. Now, that leads me to my next question. So when the refund was cancelled, you are actually due a refund of $10 million as opposed to $18 million. Now, the price of the goods was actually $18 million. Right? So therefore, you are now placing at the disposal of the seller $10 million instead of $18 million. Where does that leave you?
Sorry, Mr. Arbitrator, I missed the last point.
Right. So basically the price of goods was $18 million. Is that correct?
Yes, Mr. Arbitrator.
Goods. In terms of the set off, right, after set off, only 10 million was going to be refunded to you, not the 18 million. At that point of time, right, when you cancelled the refund, you were cancelling the refund of not 18 million, but only 10 million. Whereas the price actually was 18 million. So where does that leave you?
In any case, Mr. Arbitrator, the fact that I know that my time has elapsed, may I have 4 minutes to conclude my submissions and address Mr. Arbitrator's question? Now, because the refund was cancelled, the purchase price still remains with the respondent. And this is consistent with the position of the respondent at the start of a concluded contract, with the purchase price being with them. And therefore, the fact that we cancel a refund of a smaller quantum doesn't change the fact that a contract still persists and operates between the parties. I hope this addresses your question, Mr. Arbitrator. And I will then move on to the issue of damages and remedies. Now, because we have identified 2 breaches in the present case, damages for the delay would be one of the 2 remedies, but we will defer the analysis to my written submissions. Now, we are seeking the remedy of specific performance for the repudiation by the respondents. And Section 52 of the Sale of Goods Act grants the discretion to grant the remedy of specific performance in sale of goods contract. Now, the first issue must be to determine whether the goods satisfy the statutory definition of specific goods, essentially goods which are identified and agreed on at the time of sale, as provided in Section 61 of the Act. Now, since the allocated chemical fertilizer was indeed identified and agreed, this requirement is settled. But most importantly, specific performance is justified when damages are inadequate as the goods are sufficiently peculiar and are of unique practical value to my client. And in the context of sale of goods situations, uniqueness is not limited to rarity, but of commercial uniqueness. That is to say, something that cannot be found, something that cannot be easily be found on the market. So in the present case, the commercial uniqueness stems from two key facts. Firstly, the removal of the subsidy does not affect the present contract, which we are seeking to enforce, because the policy change, or rather the removal of the subsidy, was effected after the conclusion of the contract in September. The contract was concluded in February. Secondly, the price and quantum is unique to my client's needs, and the respondent is the only person who can fulfill since the market cannot supply. This was made up when my client had represented to the respondent to say that no alternative suppliers could be found. So therefore, in this present case, the respondent is the sole person that can fulfill my client's commercial needs. And without the remedy of specific performance, my client will not be able to run its agricultural operations and to fulfill its subsequent obligations. Therefore, it is just and fair in the present circumstances to award specific performance to my client. Unless I may be of further assistance to this tribunal, this concludes my submissions.
I would like to ask one question from you.
Yes, Mr. Arbitrator.
In your Annex 7, you refer to the fact that the respondent has acted fraudulently.
Yes, Mr. Arbitrator.
Rely on fraud as a part of your claim, or are you restricting your claim only to a contractual claim?
Mr. Arbitrator, we do not identify fraud as one of the issues to be determined in this arbitration.
Thank you.
With this, I conclude my submissions and I shall pass the time on to my co-counsel, Ms. Kit Pang.
In that case, I'll begin with my submissions. So good evening. As earlier introduced, my name is Kit Pang, and I will be continuing the case for the claimant. Following my co-counsel's earlier submissions on the issues of jurisdiction, breach, and remedies, I will now address this tribunal for the next 19 minutes on the issues 3 and 2 of force majeure and supervening illegality, respectively. The claimant had placed its trust in the respondent, a large conglomerate, to deliver $18 million worth of fertilizer for its very own cultivation operations. Today, not only is this $18 million worth of fertilizer undelivered, the respondent is also seeking to avoid the consequences of its two breaches through raising several defenses. We submit that none of these defenses are applicable and that the claimant shall be entitled to the remedies. In this regard, we have two submissions. First, we submit that the force majeure clause cannot be relied on. Thus, the claimant should remain entitled to damages. Second, we submit that the prohibition imposed by NFC does not act as a supervening illegality. Thus, the contract has not been discharged, and the claimant remains entitled to chemical fertilizer at the subsidized price. So beginning with our first submission on force majeure, which under page 5 of the record is listed as issue number 3, the respondent has in paragraph 34 of the written memorials sought force majeure relief for all 3 events under the third issue. For performance to be excused for the period of each of these 3 events, the respondent will have to prove that the 2 conjunctive requirements are satisfied for all 3 events. And these 2 conjunctive requirements are first, as provided for in clause 21.2, a condition precedent of notice of the force majeure event. We wish to highlight how the respondent has in paragraph 39 of their written memorials also accepted that notice is indeed a requirement for force majeure relief. Second, the second conjunctive requirement is that the force majeure event must fall within the ambit of the definition in clause 21. With that, I'll start with the first event, which is the delay caused by the breakdown of carrier MV Lorient. We submit that the notice requirement was not satisfied since the respondent had failed to provide sufficient notice. In paragraph 104 of the 2018 English High Court case of GPP Brickfield and Solar EPC Solutions, the High Court held that the notice requirement for a force majeure goes beyond a mere formality. The real purpose of the notice is to enable the claimant to monitor the situation and to understand why the respondent was prevented from performing its obligations, such that the claimant can then decide on its next step. That is why it is crucial for this tribunal to examine the contents of the notice to determine whether sufficient information had been provided. And to this, we submit that the communication on 10th April 2021 was insufficient. In
It was
determining,
not within the 14 days. Is that your submission?
Madam Arbitrator, while we submit, so as for the notice requirement, we submit that there are two portions to this. One is the time limit of 14 days, as you have just mentioned. And the second is that the notice itself has to contain sufficient information of 2 points. So firstly, sufficient information of the circumstances constituting the force majeure event. And secondly, sufficient information on the efforts taken to overcome the force majeure event. So the current submission that I am presenting on is in relation to that of the second requirement for the notice requirement, which is that of the provision of sufficient information regarding both the events as well as the efforts that have been taken. So we submit that these two factors should be taken into account in examining this notice on Annexure 2, which sets out the email dated 10th April 2021 from the respondent to the claimant. This can be found on page 8 of the record, and we submit that this alleged notice which has been provided is insufficient. The reason being that when we examine the first factor of whether sufficient information had been provided regarding the circumstances constituting the force majeure event, we can examine line 2 of Annexure 2, which states, your shipment on board the vessel MV Lorient has been delayed. We submit that not only has there been no information provided regarding each of the individual breakdowns, there has also been no estimate provided regarding how major of a setback the breakdowns would result in.
All they have referred to is a delay. That's the point you're trying to make out, is it?
Yes, that is exactly the point, Madam Arbitrator.
Yes.
And the reason
My
why...
question,
Yes.
my question in relation to that case, you obviously did receive this document.
Yes, Mr. Arbitrator.
But you never responded to that.
Yes, Mr. Arbitrator. I understand I note your concern in relation to how perhaps the fact that the claimant has not responded to the communication thereafter would then mean that perhaps we are accepting that this notice was sufficient and that there was a waiver of the defects in the notice. However,
And also it says in the next paragraph that your shipment will reach you in time. At that time, in Annexure 2, it said that your shipment will reach you in time. So can you rely on it as a ground for a force majeure? They are not just talking of a delay, but the delay would still allow the shipment to be reached at the correct time, isn't it?
Madam Arbitrator, I note your concern. I note that there have been two questions raised, one by Mr. Arbitrator and one by Madam Arbitrator. So I'll address them in turn.
Please do, yeah. I think you can
Madam
answer both together if you like, okay? But as you please, right?
Grateful, Madam Arbitrator. So in relation to the first point on waiver of notice, Mr. Arbitrator, I note your concern. However, it has been held that in the 1976 English Court of Appeal case of V. Burke and Son Limited and Vanden Aveen, that a buyer is not prevented from relying on a defect in notice merely because he fails to object to the notice on account of the defect when he first received the notice. This relates back to the purpose of the notice requirement that I earlier mentioned, meaning that it is not sufficient for the claimant to merely have been informed of, because it relates back to the purpose of the notice requirement, which is for the claimant to understand the full extent of the force majeure relief being claimed by the respondent and to then know what further steps to take. And as such, the burden does not fall on the claimant, but rather the respondent. And in relation to Madam Arbitrator's second question on how in Annexure 2, it has been stated that the shipment will reach you in time regardless. This relates back to how what the force majeure relief being claimed would result in. And that is as we can see on page 7 of the record, it states that the party shall, having given notice, be excused performance of such obligations for as long as such force majeure prevents it from performing them. So although it is true, according to what Madam Arbitrator has pointed out, that the shipment will still reach the claimant in time, we believe that what the respondent is trying to make out is that this period of delay of this 3 to 4 months would then be excused and not be considered as part of the delay. However, it would lie on the respondent to flesh out in detail as to the precise force majeure relief that they are currently claiming.
This case you referred to was Sunburst Plaza Limited versus Maloney. Is that the case you referred to, 1988 case?
Madam Arbitrator, may I clarify if this is in relation to the point on waiver or the point on the sufficient notice?
I think it actually talks about repudiation, sufficient notice, a lot of details in that case. You referred to a Sunbird case just now, did you not? No, I'm sorry. I thought you referred to it. That's all right. That's all right. If you have not referred to it, that's fine. I heard you say something. Okay.
No worries, Madam Arbitrator.
Yeah.
So, returning to the earlier points in relation to why sufficient notice had not been provided, this can be seen from a case of the 2018 English High Court case of GPP Bigfield. And if I may illustrate why the notice in the present case is insufficient. So, in that case, the force majeure events were protests by local residents, which had prevented the defendant from continuing construction of the solar plant. And the force majeure clause in that case was analogous to the present case. It states, and I quote, that the party claiming exoneration notifies the other party of the circumstances of a fortuitous case of force majeure. In that case, the notice provided was extremely similar in that they had merely stated that there were minor problems, mainly with the local residents, and that the defendant had a solution to these problems. So these are extremely similar statements to the alleged notice which had been provided under Annexure 2. And it is for these reasons that we submit that the purpose of the notice requirement has not been satisfied in the present case.
Because the sole effective cause of non-performance that it prevented it has not been succinctly set out, right?
Yes, Madam Arbitrator, so that the force majeure events has not been set out in detail, and also that the efforts that have been taken were not set out in detail. Yes.
Yeah.
So when was it in accordance with the contract? What was the date of delivery, or what was the period of delivery? When did you expect it? Where is the information?
Yes, Mr. Arbitrator, if I may turn your attention to page 2 of the clarifications. So the agreed date of arrival was by 13 July 2021, and this can be seen under the point Annexure 2 under the first clarification.
Okay, 13 July.
Yes, 13 July 2021. So even if the tribunal is not with me on this point with regard to the notice requirements, we submit that the respondent...
And the goods did arrive on the 12th of July.
They had arrived in the port of Rivendell on 12th of July.
Okay. So what you're saying is delivery had to be on the 13th of July, but it did arrive only on the 12th of July.
Mr. Arbitrator, we submit that the date of arrival that has been agreed on of 13 July 2021 was delivery to the claimants itself. So meaning that even though it had arrived in the port of Rivendell on 12 July 2021, this has...
Delivery did not take place.
Yes, Mr. Arbitrator, and this can be seen from page 9 of the record under Annexure 3, whereby even though it has already been 16 July 2021, the respondent still apologized for the actions, meaning that delivery has not been concluded.
Yeah, we were
Yes, Mr. Arbitrator. So, even if the tribunal is not with me in relation to the point of the notice requirement, of how the notice requirement has not been satisfied, we submit that clause 20. We submit that in order to claim force majeure relief, there is a second requirement, that is to satisfy clause 21, which is a conjunctive clause in itself. And in particular, we submit that clause 21(2) was not satisfied. In paragraph 45 of the memorials, the respondent has argued that the breakdowns could only have reasonably been provided against should there have been evidence available to prove the seaworthiness of the vessel. We respectfully submit that this cannot be the case. The respondent will not be able to discharge its burden in proving that the delays could not reasonably have been provided against because delays due to breakdowns are commonplace in the shipping industry. This is reflected in off-hire clauses in standard charter parties, such as the Shell Time 4 form. We wish to highlight how Clause 21.2 only raises the question of whether the force majeure event could reasonably have been provided against, and not whether the event had in fact been provided against. Given how parties had contemplated having Clause 21.2, but deliberately excluded standard charter party clauses, we submit that the respondent cannot prove that the delay falls within Clause 21.2. And as such, the respondent cannot rely on force majeure relief to excuse this delay. Now moving on to my second submission in relation to that of supervening illegality, we submit that the contract cannot be discharged pursuant to this doctrine of supervening illegality. So the alleged supervening illegality in question can be seen from page 3 of the record. That is, the imposition of the prohibition on the importation of chemical fertilizer to Rivendell by NFC on 30th September 2021. We would like to highlight how the respondent states on the second paragraph of page 14 of the memorial that performance of their contractual obligations has been rendered illegal due to NFC's prohibition. This is based on an unfounded assumption that the fertilizer here does indeed fall within the ambit of NFC's prohibition, to which we submit that it does not. This is crucial because it would mean that performance of the contract has not become illegal, and there would thus be no basis of discharge under the doctrine of supervening illegality. This is a tried principle following the 1957 English High Court case of St. John Shipping Corp. And Joseph Frank Limited.
Why did you say that this does not fall within the categories by NFC?
Yes, Mr. Arbitrator. So this brings me nicely to my next point in relation to how what our argument turns on, how what was prohibited was the importation of fertilizer to Rivendell. That is, the bringing of fertilizer within the limits of the port of Rivendell. However, the chemical fertilizer had already arrived in the port of Rivendell on 12 July 2021, before the prohibitions were imposed on 30th September 2021. This argument is also supported by Section 52A of the English Customs and Excise Management Act 1979, which is statute regulating the performance of custom and excises functions in the UK. Section 52A defines the time of importation of goods to be the time when the ship carrying them comes within the limits of a port. Further, we submit that this argument that no illegality has arisen is also supported on the facts. And to prove this, we would like to point out two key dates. If this tribunal may turn with me to page 3 of the record, this shows the statement of facts, and 30th September 2021 was the date on which NFC had imposed the prohibition in question. And on page 4 of the record, on 4th October 2021, Rivendell Customs then released the fertilizer from detention. We would like to invite this tribunal to draw the inference that the fertilizer had been released by Rivendell Customs on 4th October 2021, precisely because it had not fallen within the ambit of NFC's prohibition. Therefore, performance of the contract had not been rendered illegal, and the contract cannot be discharged under the doctrine of supervening illegality.
Now, I draw your attention to the statement which is there in the statement of facts, where during requests NFE to grant permission for the sale, and that permission is refused. How do you handle that?
Yes, Mr. Arbitrator, we note that you're currently referring to the date 22nd October 2022 on the facts. However, we submit that this permission is in relation to specifically the removal of subsidy, so that is supplying the chemical fertilizer to the claimant at the subsidized price. And this was what was actually, and this is what was refused through the request by the respondent. So there is a distinct issue from what we are currently arguing with respect to the issue of supervening illegality, which is in relation to the NFC's prohibition on importation.
Right.
So the point you're trying to make is, sorry. So the point you're trying
to item C, I believe, right?
Apologies, Mr. Arbitrator. I was
I think it
Continue.
relates to item C of the question issue.
Yes, precisely. Item 3C, yes.
Go ahead, please.
So, Miss, are you submitting that when the bulk was ordered and the permission to import was given by the NFC, that it was a bulk consignment of so 600 metric tons, and when the payment was made on the purchase, when the entire purchase price was paid on the 3rd of August 2021, that was a reserve quota for the complainant. Is it right? And that quota could not be given to anybody else because it came in, it was fully paid, and that was the reserve quota. Was that what you were trying to summarize at the end?
Yes, Madam Arbitrator, that is what we are submitting. So following my co-counsel's earlier submissions, what we are submitting for is that there is a single contract that persists to this day. And this single contract is what has already received approval from NFC regarding the subsidy, regarding the quota, and that is the contract that we are currently looking at today. As such, it would not be captured by the removal of subsidy as well, since this subsidy has already been agreed on and approved and given to the claimants prior to that. With that, this concludes my submissions, unless I may be of further assistance.
We wish you a very good afternoon, learned members of the tribunal. My name is Onel Edrisinghe, and I will be representing the respondent in this case, Durin Industries, and discussing first regarding the arbitral tribunal lacking jurisdiction to hear this dispute, and second regarding the breach of contract. While my co-counsel, Naika Gunaratna, will be elaborating on the other aspect. Tribunal, we request that we do not jump on this unjust bandwagon of solely blaming the respondent for the calamities caused by a third party, as the respondents have always maintained a peaceful economic relationship with the claimant. As such, we would also request the tribunal to consider the ship of justice, whereby the tribunal would revoke both parties of their obligations due to unavoidable circumstances. In regards to my first issue, I will be going over 3 limbs. First, regarding the tribunal deciding on its jurisdiction and Article 12 being a valid multi-tier dispute resolution clause. Second, Article 12.2 being a condition prior to arbitration. And third, that the condition for arbitration in Article 12 has not been met. Tribunal, in regards to the tribunal deciding on its own jurisdiction, the competence principle clarifies that the tribunal does in fact have the power to decide on its own jurisdiction. These powers are further affirmed through Article 23 of the UNCITRAL rule. Further, in regards to the multi-tier dispute resolution clause, Gary Bourne and Jason File have generally dictated a multi-tier dispute resolution clause to consider a step or steps prior to the commencement of arbitration. If I could request the tribunal to follow me to line 2 of Article 12.2. It states here that parties must initially attempt in good faith to resolve all disputes amicably between themselves, and tribunal, only failing which, the parties should submit their disputes to arbitration. Seeing that this clause covers for the use of arbitration prior to the commencement, we conclude that this in fact is a valid multi-tier dispute resolution clause.
Is there an objective structure there, Mr. Edelsinghe?
I'm sorry, Madam Arbitrator.
Is there an objective structure set out, even
in regards to the
explicitly or implicitly? Is it there? Can you identify an objective structure here?
In regards to the precondition, I will be elaborating on the ambiguity and the good faith aspect of it, and then we'll be going on to discuss the negotiation.
All right.
Thank you, Madam Arbitrator. In regards to the second limb of my argument, I will be going over 2 sublimbs in regards to Article 12's terms not being ambiguous, and second, that there is an obligation to act in good faith. In regards to the first sublimb, tribunal, the case of Emirates Trading, as per paragraph 25 in the case of Emirates Trading versus Prime Mineral Exports, it states the word shall, and it affirmed that this mentioning of the word shall affirmed this obligation and that it was mandatory. Further, as per the case facts here, Article 12.2 of the contract similarly requires the parties to initially attempt in good faith to resolve these disputes between themselves. Further, Paul Friedland, a renowned arbitrator and Band 1 practitioner, held that and explained that the language in a contract should reflect its mandatory nature through words like shall over preference to words like may, and for this prior step of arbitration in order to eliminate ambiguity in the terms. We feel the respondent has adequately addressed and has effectively met these terms, and thus we submit that the word shall eliminates ambiguity in the nature of the prior step. On the basis of the reasoning in Emirates Trading Tribunal, the parties here too have agreed to solve their disputes in an amicable manner before resorting to arbitration, and thus why the condition in Article 12.2 is in fact enforceable. In regards to good faith, though we understand that there's no firm definition for good faith in the law tribunal, and this is due to the fact that the parameters for good faith are incapable of being defined due to objectively behaving in good faith being inapplicable. And this is as per the case of Shaker versus Vistachat. However, Professor yes, ma'am.
Can I pause you a moment, please? But does not the communication from you dated the 26th of October 22 almost say, well, there's no negotiation here? Did that in a way not compel the claimant to institute arbitral proceedings?
We would consider that there was grounds for negotiations by arbitrator, and that has not taken place. This was merely email communications that have taken place. And I will be also elaborating on how negotiations are a possibility and why we can negotiate this agreement. In regards to returning to my submission, Professor Yvonne McKendrick has asserted that there are instances where obligations for good faith were upheld. Per Tier J's dicta in Emirates Trading, he provided a general standard to follow for the purpose of good faith communication. He stated that they should be first, fair, second, honest, and final, genuine. We argue that the claimant and respondent, had they been given the opportunity to negotiate, could have easily met this possibility for resolving it through negotiation. And in order to prove so, I request the tribunal to follow me to Annexure 5, Line 4. Here, the respondent's fairness is clearly displayed, as here, a day after receiving the request for a refund, the respondent was ready to provide the said refund, and the claimants also portrayed their genuine and honest intentions through explaining the situation that they were in for this refund. Thus, it is clear that the parties did in fact have the capacity to negotiate. The further case of HSBC Institutional Trust Services versus Toshin Development highlighted a case wherein the court held that an agreement to negotiate was an extension to the existing contract. This meant that the parties weren't free to disregard such obligations so easily, and thus, tribunal, it is clear that as per the actions of the respondent in this case, there were intentions to impose an obligation of good faith and amicable settlement prior to submitting these disputes to arbitration.
Can I just ask, don't you consider the discussions and discussions with regard to the refund, the refusal of the refund, then the discussions with NFC to see whether they can go? Isn't that sufficient? Doesn't that come within the parameters of a negotiation?
That's a great question, Mr. Arbitrator, and we would consider that to not be adequate means for negotiation, seeing that it was merely a back and forth of explaining the positions to the other side, and thus not adequately meeting what we would consider to be objectively negotiating with another party. That means to come to an amicable settlement. I hope that has addressed your question.
I have a
You
question.
do a distinction, yeah? Okay.
Yeah. I have a question. Now,
Yes, Mr. Arbitrator.
see whether there was negotiation taking place, one has to see when the dispute arose. According to you, when did the dispute arise in relation to this?
In terms of the general dispute had arose on two occasions. We believe it's first in regards to the refund that had begun, and second as to the subsidized price.
So was there in fact a dispute in relation to the refund? As
We
far
believe
as the refund was concerned, they asked for a refund. You offered to give a refund. You said that there will be a set-off that will take place, and they did not object to that. So where is the dispute in that?
we believe that this was that was a great question too. Regards to that, we would regard that to be the result of the delays, and further, we received no response back to that, and we cannot consider silence to be valid acceptance per Feldhaus versus Windley and the dicta held in that case. That's why we consider that dispute is unresolved.
But Mr. Singh, isn't the dispute non-delivery and
That's the contract.
the fact of negotiation, the refund, also sorry, the refund part was a negotiation of or trying to negotiate a settlement with regard to the fundamental breach of non-delivery. Isn't that the dispute before the tribunal?
Good afternoon, Tribunal. My name is Naika Gunratna, and I am the co-counsel for the respondent, Durin Industry. Tribunal, the claimant's case is subsumed under the idiom that the devil is in the details, as while prima facie, it seems as though the respondent is responsible for all the havoc in the claimant's plantation. But upon closer inspection, it is in fact the actions of the NFC as a third party that has disrupted otherwise peaceful transactions between these two parties. In my pleading, I will be providing 3 extensive points of argumentation to the established arguments by my co-counsel Onel Edisinger, who established that 1, the arbitral tribunal lacks the jurisdiction to hear this case. 2, the respondent has not breached this contract. The 3 points of extensive argumentation I will be providing is 1, the NFC's prohibition of importation of chemical fertilizer amounts to a supervening illegality. Second, the chain of events has frustrated the contract in regards to the obligation of delivery, and the obligation in regards to price has amounted to force majeure. And third, that the respondent is not entitled to pay damages nor specific performance. With the tribunal's permission, I will now be addressing the first issue, which is that the NFC's prohibition of the importation of chemical fertilizer amounts to a supervening illegality. There are 3 sub-issues to this argument. The first is that performance has become illegal. The second is that there is a permanence in frustration, and the third is that it is temporally encapsulatory of the contract in question. The first, in regards to performance being illegal. According to the case of Avery versus Bowden, it stated that in the event that contractual performance becomes illegal by virtue of a government regulation, such an event would amount to a supervening illegality. It is the claimant's contention that this prohibition in fact does not fall within the ambit of performance. However, and if I may direct the tribunal to the statement of facts, the MV Lorraine was detained on the 12th of July 2021, within which the prohibition on the importation of chemical fertilizer was imposed on the 30th of September 2021. And it was only on the 4th of October 2021 that the MV Lorraine was in fact released. And it was at this point that the claimants wished to continue performing the contract. However, at this point, performance was prima facie illegal as the prohibition was still in place. However, the second sub-issue...
Sorry, the prohibition on the fertilizer, is it? The illegality of the subsidy.
Yes,
that is the point. All right.
Yes. The second sub-issue is that there is permanence in regards to this frustration, as while we concede that the prohibition would be removed only 10 days later, according to Professor Ivan McHenry, the permanent nature of an illegality is adjudged based on whether it is fundamental or substantial to the contract. Further, the case of Jackson versus Marine Insurance adds the threshold that it must frustrate the commercial object of the contract. In the case at hand, there was havoc caused in the claimant's plantations on the 3rd of August 2021. Hence, every day after such a day is a commercially unviable time for the claimant. Hence, from a commercial standpoint, delivery of the goods on the 14th of October 2021 would in fact still have frustrated the commercial object of the contract. However,
can I just ask you, so are you have you considered whether this was just a force majeure because ultimately the ban was lifted. So isn't that a force majeure event rather than a frustration of the contract itself?
Mr. Arbitrator, we would argue that it's a frustration, as this has frustrated the commercial object of the contract, and hence, in the event that they had delivered it at a reasonable time, there would have not been havoc caused in the plantations, which would ensure the commercial object of the contract. However, as a result of the illegality, this has in fact been frustrated.
So what you say is that the force majeure clause, which permitted the non-performance of an obligation whilst permitting the existence of the contractual obligations on the parties to the contract. Is that what you're saying?
Sorry, Madam Chair, could you reiterate the question?
So does the force majeure clause permit non-performance of an obligation whilst permitting the existence of the contractual obligations on the parties in the contract? Is that what you're saying? Isn't that, I think, Mr. De Silva,
That seems to be what they are saying.
yeah, that's what I'm saying.
Yeah.
Right.
Now,
All right.
Now, my question is, you adverted to a prohibition. What is the prohibition that you're adverting to?
The prohibition on the importation of chemical fertilizer.
So when did the prohibition come into existence?
On the 30th of September 2021.
So by the time, weren't the goods imported into the country? Weren't the goods already in the port?
In regards to that, Mr. Arbitrator, that moves me perfectly into the third sub-issue, which is that it is temporally encapsulated. The contention here is the claimants argue that the time of importation has been completed, as according to Section 5, subsection 2, paragraph A of the Customs and Excise Management Act 1979, as the ship had arrived in the port of Rivendell, that the goods had in fact been delivered. However, if I may direct the tribunal to the statement of facts, just below the mentioning of the arrival of the ship, it is also mentioned that the goods were in fact seized by the Rivendell Customs. Hence, if you apply the purposive approach of when the ship arrives at the port, we would submit that the goods should be ready to be delivered to the buyer. However, in this case, the goods are not ready to be delivered as they have been taken by the Rivendell Customs. Hence, performance at best would be on the 4th of October 2021 when the goods were in fact released. However, at that point, the prohibition was still in force and hence performance was in fact illegal at that time.
So was it the prohibition actually or the action of the customs that affected?
Mr. Arbitrator, we would argue that it is in fact the prohibition as well, considering that the ship was requisitioned. However, since the prohibition was imposed, they could not continue performance on the 4th of October 2021, and hence there was that frustration that occurred.
In other words, what you're saying is that it's a combined effect that affected you.
Yes, Mr. Arbitrator.
Yeah.
Brief suggests that there is a lack of prima fides on the respondent because you had knowledge of the cancellation of the subsidiary prior to the time when you actually notified them of it. Is that, what do you have to say to that?
Yes, Madam Arbitrator, we would submit that there is a difference between the imposition of a prohibition as opposed to the removal of a subsidy, as a prohibition limits all imports of a particular good, while a removal of a subsidy only reduces or limits. And we will argue as to why this has amounted to force majeure in our next argument. Based on this, I will now address the second issue, which is that the contract has been frustrated due to the delays and amounts to force majeure due to the removal of the subsidy. In regards to the delays that have been caused, we agree with the claimants when they say that a reasonable time of delivery would have in fact been the 13th of July 2021, which is also there on the points of clarification. Based on this, a frustrating event would occur as per Lord Radcliffe in Davies Contractors versus Fairham, when A, it is not the fault of the parties, and B, there has been an impossibility in performance of the obligation, and C, the contractual performance has become radically different. The first circumstance is the delay caused by the breakdown of the carrier. This is not the fault of the respondent, as we contend that the MV Lorraine was in fact a sole ship owner who the respondent had in fact chartered. Hence, the responsibility is in fact on the ship owner as opposed to being on the respondent. We further submit this based on, and if I may direct the tribunal towards a statement of facts, on the 15th of June 2021, the respondent had clearly mentioned the ship MV Lorraine in specificity, and therefore there's a degree of autonomy to the ship, which we submit is in fact another ship owner, and hence the delays, or rather the breakdowns, was in fact not the fault of the respondent. This had caused a change in the obligations, as it had caused a 3-month delay. However, we don't base our frustrating event solely based on this, but we consider it to be a chain in regards to the proof of frustration, which we combine with the second circumstance, which is the delay by the detention of the stock. This was not the fault of the respondent, as, and if I may direct the tribunal towards Annexure 4, I beg your pardon, towards Annexure 3, this was on unfounded charges and was hence not expected by the respondent. To justify this statement, I request the tribunal to come back to the statement of facts, where on the 14th of February 2021, the NFC had allocated the supply of 600 metric tons of chemical fertilizer to Noldo, but further, on the 15th of June 2021, they had requested the respondent to deliver the goods on the MV Lorraine, and hence the procedural requirements laid out by the NFC have in fact been tallied. But we further submit that according to Annexure 5, there were previous transactions between these two parties, which we submit would have been unhindered, thereby inviting the comment that it was on unfounded charges, thereby making it a new third-party involvement. We further submit this has caused a radical change in obligation, as this adds up to a 6-month delay in tally with the first delay. Hence, what we submit is that this is similar to the case of Jackson Marine versus Insurance, where a 6-month delay had in fact frustrated the contract, as Bramwell B stated that the commercial object of the contract had in fact been frustrated. We submit that this was in fact the havoc that was caused in the claimant's plantation due to the lapse or the delays that had been caused. We argue on the second limb that there was force majeure in regards to the removal of the subsidy. For this, we need to establish, as the claimants pointed out, Article 21's requirements and Article 21.2's notice of force majeure. And that is exactly what I will do in my pleading. The removal of the subsidy amounts to a supervening illegality, as 1, it is beyond the party's control, as the case of Liubipin versus Crispin states that direct legislative and administrative interferences would in fact amount to a force majeure. In the case at hand, this was the removal of the subsidy was imposed on the 30th of September 2021 by the NFC, and hence is government action which is beyond the respondent's control. Second, this is not reasonably provisionable against, as the respondents would not have known of this. However, we will concede that on the 9th of November 2021, the respondents had been known of the impending removal of the subsidy. However, this is still ambiguous, as there is no certainty as to whether the subsidy would in fact be removed or not. And therefore, we further submit according to Annexure 5, that because there were previous transactions that had gone unhindered, the respondents would foresee that there is no hindrance that's going to occur. The third point is that this was not reasonably avoided, as if I may direct the tribunal towards Annexure 6, while the respondent and claimant had in fact contracted for the supply of 600 metric tons of chemical fertilizer at the subsidized price of 18 million. On the Annexure 6, it is stated that the respondent's request to supply it at such a price was rejected by the NFC, and hence they were to only provide those goods at a new purchase price. We would further.
Naika Gunaratna, you are claiming that the delay in the merchant vessel Lorient was part of the delay and was part of what led to the frustration. That was a delay, it was beyond your comprehension, you couldn't control it. But why did you not, in that case, inform the claimant that this was a delay? It looks as though some sort of notice to them, because your assurance has been, well, that won't affect the shipment reaching you in time. Isn't that mutually contradictory? Your submission is that, well, this was the beginning of it. I mean, any one of these could have separately or collectively caused a breach, resulted in the breach of the contract, and justifiably so. But you have assured the claimant in this Annexure 2 that, well, don't worry about this. The shipment will reach you on the correct time. So aren't you precluded from arguing then that this is part of a chain of circumstances that led to the frustration of the contract or the force majeure? Do you accept that?
Madam Arbitrator, we respectfully submit contrary to that notion, as yes, we do agree that they stated that we will attempt to deliver it on time. And to a large extent, what they stated was in fact true, as the MV Lorraine had arrived at the port of Rivendell on the 12th of June 2020, 12th of July 2021. And the reasonable time of delivery was the 13th of July 2021, which was 1 day later. Hence, if the NFC if the Rivendell Customs had not taken the ship, had not requisitioned the goods, that reasonable time of delivery would have in fact been possible, thereby suggesting that this was not merely a lie or any type of fraudulent statement.
So the point I was trying to sort of discuss and ask your arguments were, because your argument was there were several, and you began with the delay in the ship. That would really not be relevant, isn't it, at this stage? The first thing that really occurred was the illegal arrest of the ship on the 12th, right? That was the first thing that occurred.
We would submit yet again that the delay in fact caused a delay, and hence they had to go right to the line at the last date of delivery. In the event that that delay had not occurred, they could have possibly delivered the goods even earlier and thereby be able to provide the goods on time.
So your assurance that it will reach you in time was not based on any contingencies, but it was an outright assurance. But your point is taken. You can continue.
Okay, just one more query. So your timeline is the delay on the vessel. Okay, that's force majeure, right? Am I right?
The delay caused by the breakdown of the carrier was a frustration.
It's a force majeure event.
Frustration. It's going frustration.
No, is it frustration of force majeure?
It
is the frustration.
Frustration.
Yes.
Okay. Then the customs requisition. Okay.
Yes.
Then the ban on importation. Okay.
Yes.
Then the subsidy. Okay. So you say all these are frustrating events, or all these are force majeure events, or some are frustration, some are force majeure. Because from what I gathered, you seem to jump from one to the other to the other. Yeah, it's because if it is frustrated, force majeure is completely out of the system. No? Frustrated means contract comes to an end at that time. So your frustrating event necessarily will have to be the last event. Force majeure will delay you or give you time enough to come to the frustrating event. Is that what you're saying, or what you're saying is different to that?
Mr. Arbitrator, in regards that we would submit that the delays had in fact frustrated the obligation to deliver it at a reasonable time, while what we are submitting in regards to force majeure is that the removal of the subsidy, while it suggests that the obligation would be allayed so long as such an intervening event has taken place, we would submit that this removal of the subsidy amounts to a force majeure, and hence, as they cannot continue with such an obligation, we would submit that they are removed from actually delivering at a subsidized price.
So again, frustration.
We would submit that it's a force majeure.
Force majeure. Okay.
Okay. Now, in that context, I go back to my question, because you're dealing with price, right, and subsidy. Now, subsidy was removed on the 30th of September. You were requested to supply the goods back again on the 4th of October. By that time, you knew that the subsidy was removed. And on the 4th of October, you're agreeing to supply it at 600. You're free to agree, and you voluntarily agreed. How can you now rely on the subsidy or the lack of subsidy again?
Because that is the Uberima fee days that has been complained of, that you knew before that, the second contract.
Can you address us on that?
Tribunal, to address this question, if I take the tribunal back to the 4th of October 2021, it was in fact the claimants who had requested for such performance, and we agree with that. However, there was no acceptance on part of the respondent to continue with the contract on that particular date. As if I may direct the tribunal to Annexure 6, this was the response that the respondent had given to the claimant, where they have not agreed to continue with the subsidized price, but they have agreed that stating that the NFC's prohibition, or rather the removal of subsidy, has resulted in them having to supply it at a new purchase price. And despite all their efforts to supply the chemical fertilizer at a subsidized price, has in fact been allayed. Based on that,
would you not have an obligation to have indicated to them when they inquired you to supply at a subsidized price, to inform them, look, we may or may not be able to do that. We will check. You don't seem to have done that, have you?
in regards to the notice of force majeure, what we would submit is that on the 3rd, while there was a prohibition removal imposed on the 30th, there was a time period where the claimants had requested for a refund, thereby suggesting that they would not want a notice of force majeure, and the only time the clock of notice of force majeure starts is in fact on the 14th of October 2021, thereby 14 days from then is actually 28th of October 2021, and therefore as this notice has been given on 26th of October 2021, that in fact complies with the notice of force majeure. Based on this, I will now be addressing the last argument, and seeing as I'm about to go over time, would it be possible to get an extension of 3 minutes to—
Of course,
finalize?
we have all been giving you a lot of questions, and yes, you are. I
Thank
take it
you.
it's okay with the rest of the arbitration.
Yes, of course.
Thank you, Tribunal. I will now be addressing the last issue, which is that the respondent is not entitled to perform specific performance nor pay damages. The first is that the damages caused in the claimant's plantations are too remote in this instance, as the case of Hadley versus Baxendale sets out 2 requirements to claim damages. A, it must be a natural cause, and B, it must be within the contemplation of the party. However, A, this is not a natural cause, as according to the case of Young versus Purdy, a breach of contract by a solicitor resulted in the client experiencing loss. However, the client going without legal advice and all those losses only was capacitated by the breach of contract, but was not the natural and direct cause. We submit the same circumstance here, where although the fertilizer was not delivered, the claimants could have in fact found other suppliers or even gone international in order to get other suppliers. We would submit that this was in regards to contemplation of during the contract, there was no contemplation that a third-party event would break the chain of causation, which has occurred here by the requisition of the ship at the port of Rivendell. The second limb is that there is no right to specific performance, as the claimants contend based on Halroyd versus Marshall that these goods are invariably important. Upon their own logic, it suggests that the chemical fertilizer is what's more important compared to the price. They did not specify as to why they need it at the subsidized price. They merely stated as to why it is the chemical fertilizer itself is required. Hence, we further submit that according to the case of Beswick versus Beswick, where Lord Reed stated that a specific performance must be a just result, we do not see any just result where the third-party interventions had broken the chain of causation and had hindered the ability of the respondent to deliver the goods on time, had hindered the ability for them to provide the goods at the subsidized price, and therefore we submit that the damages are too remote and there is no specific performance. Tribunal, the only just result is to not blame the respondent solely for all the havoc caused in the claimant's plantation, and it is far better to set aside the contract.
Yeah, can I have you finished it, Tammy? Can I just get 1 minute to ask him a question and give him a minute to answer that? Is that permitted, or would that go against anybody? Do we have the agreement of all parties to this arbitration? It's a 1 minute, but I think it's also going to help the claimant in this matter. So
Yeah.
you see, normally the general rule is under section 16 of the Sale of Goods Act 1979 is that when it is unascertained goods, no property in the good is transferred to the buyer unless and until the goods are ascertained. But under section 20A provides the exception where there is a contract for sale of a specified quantity of unascertained good which forms part of a bulk, and the bulk has been identified by the parties. In this case, 600 metric price for the tons for the price of 18 million. Then property is transferred unless the parties agree otherwise at the time that this invoice has been raised and the payment has been made, right? So here is a quota given by NFC, and they have been told that part of that quota included the name of the claimant in this case, correct? Original quota, right? And in that, so the goods were a part of a bulk goods that was in that consignment. And it had the ratification of a subsidy by a government institute. But when it landed, what happened to those goods? Why could those goods not be given at the subsidized rate? Because title had already passed to the claimant on that.
In regards to that point, Madam Arbitrator, we would state that the goods had not passed to the claimant at that time, as the goods were requisitioned by the Rivendell Customs. As previously established, at best performance would be possible on the 4th of October 2021. However, even at that instance, there was a prohibition that was imposed, and therefore the goods could not be legally taken into the country or legally taken by the claimant. And hence we submit that the goods had not in fact passed, while even in the instance where those goods were to be passed on the 14th of October 2021, such performance would in fact have frustrated the contract because it has passed the reasonable time of delivery. And based on that, we submit.
Members of the tribunal, we have 3 points in rebuttal. On to my first point of rebuttal. I note that counsel for the respondent did not address the certainty requirement of the dispute resolution clause, but nevertheless, we are willing to take the respondent's case at its highest that the clause is perhaps indeed enforceable. However, counsel for the respondent has conceded that negotiations are futile. And then he contradicted himself to say that negotiations are possible. This cannot be the case, as rightly pointed out by Mr. Jayasundari. This must mean that either negotiations have indeed failed and the dispute resolution clause is indeed satisfied, or that negotiations are futile and this tribunal should then waive the requirement to negotiate pursuant to Article 17, 1 of the unsectoral rules of arbitration, so as to prevent unnecessary delay and expense. Now, moving on to my second point in rebuttal, we note that counsel for the respondent has argued that the delay caused by the delay caused by the ships were matters that were out of the respondent's control, and he argued that the presence of a third-party carrier excuses the respondent. However, we disagree. The 1996 English Commercial Court case of the Quitty Rex suggests that where a party delegates its duty to perform under a contract to a third party, in this case, which means the respondent will delegate its duty to perform under the carrier, the carrier's what events under the carrier's control would be within the respondent's control, and we submit that the respondent has failed to discharge its burden of proof to show that the breakdowns were truly matters outside the carrier's control. Lastly,
may I just say, but Mr. Code, don't you ultimately they did deliver before the time of, or they were ready to deliver on the 12th of August, I think, right? Or sorry, yeah. Anyway, they were ready to deliver even with the delays. They were ready to deliver before the time of performance was there, right?
Mr. Jayasundara, I note that my time is up. Perhaps I can have
No, that's okay. Go ahead.
Yes,
Right.
yes, Mr. Jayasundara, we know that the goods were in fact delivered on the reached the port on the 12th of July. However, this is to address the respondent's argument that they are suggesting that the delay amounted to a frustrating event. We are simply rebutting that argument. Now, moving on to my last point on rebuttal regarding the remoteness of the damage. Counsel for the respondent seem to have conflated the issue of remoteness and causation, in that the damages caused as part of the non-delivery were too remote, considering that using the events of the shipping delay and the detention. However, these events must be seen as events that break the chain of causation rather than remoteness, and we submit that the counsel respondent has erred in law. Nevertheless, even if we were to submit that the events could amount to supervening events.
The time is up.
Yes, I note that my time has elapsed. Unless I may be of further assistance, or would you like me to continue?
You can ask for time if you like, because you are entitled to ask for 5 minutes of time.
Grateful, Ms. Arbitrator. I'll just need 2 minutes to conclude my rebuttals. In the present case, counsel for the respondent has failed to discharge its burden of proof to show that the subsequent events were truly supervening events. They have failed to prove why the delays, the reasons for the delays, and the reasons for the wrongful detention. They simply asserted that detentions were truly wrongful. It could be a multitude of reasons. And Section 27, Article 27(1) of the arbitration rules puts the burden of proof on the respondents to show the facts so as to support its claim or defense, and which we submit the respondent has failed to do so. Therefore, remoteness causation is satisfied in the present case. Unless I may be of further assistance to members of the tribunal.
Tribunal, I have 3 points of responses to their rebuttal. 1, they state that we are contradictory when we say that there is a capacity to negotiate. However, this still suggests that negotiations haven't taken place. However, there is capacity between the parties as business parties to in fact come to negotiations and in fact negotiate the conflict. Therefore, what we submit is that the arbitral tribunal lacks jurisdiction as such a step has not been taken, but in fact can be taken. The second point of response, they state that third party suggests that there's always responsibility on the respondent in this case. However, what we submit was that the delays that had been caused was in fact a chain, where in the case of the NEMA, it was stated that in the chain of frustration, an event's effect is more important than its particular cause. And in this case, there was a 3-month delay that was caused that added to the chain of events. The third point is in regards to the fact that we did not establish remoteness. We clearly established remoteness, but they haven't responded to this, considering that we stated that it was not a natural cause of the delay, as they could have, in fact, found other suppliers. Even if there weren't suppliers regionally, they could have easily searched for suppliers internationally, and therefore we submit that it was in fact remote, as while we agree there was capacity for this to cause those certain damages, it wasn't the direct and natural cause of it, therefore we submit there is remoteness. The arbitral tribunal lacks the jurisdiction to hear this case. The chain of events has frustrated the contract. The removal of the subsidy is force majeure, and the damages are too remote, and the specific performance is unjustified. Therefore, we submit as the respondent that the contract should in fact be set aside.